Pardon me? Okay.
The original indictment's in there.
Great. All right, this is case number 2026 CR 24024 LHB, State of Georgia versus Jessica Marie Moats. Present today, we have counsel for the state, Mr. Buckler, and Ms. Jackson, and we have new counsel for Ms. Moats, Mr. Alexander, the public defender for our circuit, and Ms. Riles, who is with the Capitol Public Defender's Office. The court's last hearing was a first proceeding, and at that time, Mr. Law and Mr. Dowdy were representing Ms. Moats. And at that time, we went through all of the requirements under the uniformed appeal process so that, the court's intent is to do that again today with new counsel. Ms. Moats is present and in the courtroom and has been dressed out at the request of defense counsel. The indictment in this case was filed on January 12th of 2026, and the state filed a death penalty notice on March 2nd of 2026. The clerk provided notice to the Supreme Court on April 17th of 2026. Defense counsel at the time filed a motion for continuance on March 18th of 2026, requesting that the first proceeding not be held until after the autopsy report was provided. The court set the first proceeding out sometime, but was not going to wait until after that autopsy report had been provided. There were motions filed by Mr. Law back on December 31st of 2025 that included discovery motions. At the time of the first proceeding, copies of the Unified Appeal Procedure were provided to the state, the defendant, defense counsel, as well as the court reporter. And the court reporter is instructed to ensure that all proceedings are completely transcribed. All parties and attorneys are instructed to read and adhere to the Unified Appeal Procedure. And a reminder for counsel that the outline and checklist are intended to assist defense counsel in protecting the defendant's right, but it certainly remains your responsibility to protect these rights. And the outline and checklist certainly don't take the place of diligent defense counsel actively representing the defendant. As I stated, defense counsel, Mr. Law, at the time has already filed for discovery under 17-16-1, and a new motion filed by new counsel for discovery has already been filed as well. I'll remind both parties that reciprocal discovery has been requested and information provided by the state and provided by the defense should be accurate and complete. Mr. Buckler, the last time that we were here, you stated that all discovery had been provided absent the autopsy report. And has that autopsy report since our last hearing, or since the first proceeding, has that been provided?
It has, Judge.
It has. So all discovery from the state's perspective that you have in your possession that is available to you has already been provided.
All discovery has been provided that's in our possession and that I'm aware of. As I've indicated, I know I've told Mr. Jackson this, I've not told Ms. Riles, but of course, if there's anything else, Mr. Alexander, sorry, if there's anything else that they need assistance obtaining, of course, we'll also be able to assist with whatever else. But everything that we have that I'm aware of has been turned over.
All right, but the autopsy report that you referenced at the last first proceeding has already been turned over.
That's specifically, yes.
Thank you.
Did come into our possession in the GBI, and we did turn that over.
Thank you. Ms. Riles, at the last first proceeding, defense counsel announced that they intended to present a challenge to the composition of the county master jury list or the manner in which the grand jury was selected. And it appears that you have already filed challenges to the grand jury as well as the Traverse list. Is that correct?
Your Honor, we have filed the challenge to the grand jury. We have reserved the right to file a challenge to the petit jury because, as Your Honor is very well aware of, at this point in time, we do not know,
Who is going to be on the list?
Yeah,
Yes.
exactly. But we did file the motion on the grand jury, and prior to filing, we shared it with the state because it also contains a protective order. And within that protective order is information that we would need in order to properly investigate the grand jury in Hall County. We do have an expert that is already on board, and I believe I shared that name with Mr. Buckler as to who that is, which he will, of course, the state will be free at any point in time to talk to him. That name has also been shared with the Superior Court clerk so that he knows who it is. However, that protective order, prior to getting any information from either the counsel for Superior Court clerks or from your county clerk here or jury manager here, that protective order needs to be signed. And I don't know if you've had time to read that protective order because it was just filed.
It was filed yesterday, I believe, correct?
Yes, ma'am. But that protective order includes a lot of information that that what it does is it makes certain that the information does not go beyond where it needs to go to. In other words,
You're not sharing grand jurors' information?
No, we're not sharing confidential juror information. This was something that we used to just do orders to the different entities in order to get the information, but through the years we discovered that probably the best way to do it is through a protective order.
And does the state have any objection to the court granting that protective order that keeps the information of the grand jurors confidential?
No objection, Your Honor. Ms. Riles did send us copies prior to filing, and we did have a discussion about that. I told her I was likely not going to have a problem. The state has no problem, but probably appropriate to not divulge some of the information publicly.
All right, and I will, based upon, go ahead, Ms. Riles.
I'm sorry, Your
No,
Honor. And I was just going to say that I know that the court originally had, I think, a date of August the 3rd or sometime early August set for that.
It's August 3rd.
Okay. In obtaining this information, it does take a little bit of time to gather the information, and then, of course, it takes our expert some time to digest that information. And once he prepares any exhibits, we also provide that to the state so they can review those exhibits. And if they see that they need to
hire their own expert.
Hire their own expert or get their own individuals down. So we're actually asking the court to move that August 3rd date to September the 4th. I've talked with our jury consultant, and if we can go ahead and get the information, if it goes ahead and flows smoothly. In other words, like once you sign the protective order and the clerk's office has it and the counsel has it, if they go ahead and provide the information within a reasonable time, which we anticipate it will be done. If it's not done, of course, that's something we can bring to the court's attention. September 4th is the date that he thinks he can be prepared for, with also giving the state, I think, some time to review the material that he may provide, and it's also a date that we know that he is available.
And September 4th is a date that's already included in my scheduling order for, I think it was non-evidentiary motions, and you're asking to also include the challenge, the grand jury, composition of the grand jury on that date.
Okay, Your Honor, we're asking only for the challenge to be done that day. It could be 3/4 of a day to a whole day on a challenge. We anticipate filing many more motions, and so we would like to talk to the court at some point in time in reference to the scheduling order, because at this point in time, with the number of motions that we need to file, that we are asking for that to be put off into the future. We will be asking for, at this point in time, for probably 90 days in order to file those motions. And of course, I think as Your Honor knows, this is the type of case, it's a two-pronged case, of course. It's the guilt innocence in there. So we have the duty not only to, do the factual investigation of the case, we also have the duty to do a mitigation investigation of that case. And, and up front, I can tell the court that mitigation investigations can take quite a bit of time I think, Judge Bearden here several years ago that handled a case, I think his name was Jeremy Gibson, I believe. And while that case, it started in 19, and I believe it actually resulted with a plea in 2024. And I know that was through COVID, but it would have been, a couple of years anyway, even if you go from after COVID ended until that case was to the point that a resolution was had in. And of course, that resolution was without a trial. But I say all of that to say that, I have a duty to abide by the ABA guidelines, but I also have, a duty, as the court said within the unified appeal, that all of these issues have to be explored. And with it being a death penalty case, and I understand the court making a scheduling order, but it's my responsibility, I think, to say that at this point in time, that type of scheduling order, that I do not see how we could be prepared to go forward.
And so I saw that you filed a motion to continue today's arraignment to the next available date, that August 3rd date. And in the event that the court is willing to adjust its scheduling order to allow some additional time to file motions, do I need to continue the arraignment for today? Or is the request to continue the arraignment really more based upon the requirement for you to file motions 10 days from today's date?
Your Honor, of course, all of that plays into it, but of course that with the death penalty cases, I've never had a judge yet to hold me, or anyone that I know of that's represented someone in the modern era in a death penalty case, to the 10-day rule.
Recognizing that, yes.
Just because of the nature of the case. We also filed a special demurrer, which I'm certain the judge has noticed that. So if the court does want to proceed on the arraignment today, we would ask to reserve the right, of course, to have the special demurrer, and perhaps we could do the special demurrer either August the 3rd or do it prior to the grand jury challenge. And we would ask to do it prior to the grand jury challenge, of course, because if the court were to rule, that it is demurrable, then there would be no need for any further motions. And if Your Honor ruled that it was fine, then of course we could go on into the grand jury motion.
And so the court would like to go forward with arraignment today,
Yes.
and then discuss after arraignment a scheduling order that fits your schedule, the state schedule, and the court schedule. I don't know that I can give 90 days, but the court certainly would give a additional, certainly never 10 days from today's date to address it. And would likely handle the special demurrer on that August 3rd date, since I already have that set aside for this case. And then the grand jury matter, that September 4th date, and we'll simply put off additional motion hearings once we figure out how much time we'll give to parties for filing motions.
And I would say also, as to filing motions, that typically in a death penalty case, we file anywhere, 90 motions up.
Yes.
Depending upon, we have, of course, standard motions in every death penalty case. And then, of course, there are motions that will be strictly construed to the facts and circumstances of this particular case. So that is one of the reasons, of course, we ask for that time, but also understand, if the court, restricts that we can also ask for further time, which would be my duty to ask for further time if I saw that.
If it became necessary.
Yeah. Yes, ma'am. Yeah. One of the reasons too, we had asked for the arraignment to be continued until the 3rd and do the special demurrer at that point in time is that with this indictment, we are trying to determine if the indictment is sufficient enough, has enough information to go forward. And in order for her to properly enter a plea on that indictment, to know what the charges are in order to be able to to even say, hey, yes, I understand what's here, or we understand what's in there, and to go forward. That was actually the chief reason, or one of the reasons for asking to do the arraignment on the 3rd, after we do the special demurrer.
And I'm sorry, I have a hard time understanding that argument, given the fact that understanding what the charges are, the indictment's been filed since January 12th of 2026, and she has been represented the entire time, has not had any time where she has not had an attorney. And so I don't quite understand your argument that additional time is necessary, given the fact that you've already filed a special demurrer. Why can't we go forward with the arraignment today?
Well, it's knowing what charges that she's actually understanding exactly what she is facing, and of course that's the whole reason for the demurrer. Now again, understand the court's position on it.
Because the demurrer has already been filed.
Yes, ma'am.
Well, the court's going to deny your motion to continue the arraignment and proceed with the arraignment today, but we'll come back and discuss an alternate scheduling order to give you sufficient time to file motions and sufficient time for the court to set aside time to hear those motions. Ms. Moats, thus far, have you been pleased with how all of your attorneys, whether or not that was private counsel before and now appointed counsel, have been representing you?
Yes, ma'am.
And is there any issue that you need to address with the court?
No, ma'am.
All right, Ms. Moats, in indictment number 2026 CR 24 LHB, you're charged in count 1 with the offense of malice murder, which reads, in the name and on behalf of the citizens of the state of Georgia, charge and accuse Jessica Marie Moats with the offense of malice murder, for that the said accused in the county of Hall in the state of Georgia between the 25th day of October 2025 and the 26th day of October 2025, the exact date of the offense being unknown to the grand jury, did, with malice aforethought, cause the death of Autumn Fox, a human being, by subjecting her to blunt force trauma by means unknown to the grand jury and exposing her to fentanyl, methamphetamine, and xylazine, in violation of Official Code of Georgia annotated section 16-5-1, subsection A, contrary to the laws of said state, the good order, peace, and dignity thereof. In count 2 reads, and the grand jurors aforesaid in the name and on behalf of the citizens of the state of Georgia charge and accuse Jessica Marie Moats with the offense of felony murder, for that the said accused in the county of Hall in the state of Georgia between the 25th day of October 2025 and the 26th day of October 2025, the exact date of the offense being unknown to the grand jury, did, while in the commission of a felony, to wit, cruelty to children in the first degree, cause the death of Autumn Fox, a human being, by subjecting said child to blunt force trauma by means unknown to the grand jury and exposing the child to fentanyl, methamphetamine, and xylazine, in violation of Official Code of Georgia annotated section 16-5-1, subsection C, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3 reads, and the grand jurors aforesaid in the name and on behalf of the citizens of the state of Georgia charge and accuse Jessica Marie Moats with the offense of cruelty to children in the first degree, for that the said accused in the county of Hall and the state of Georgia between the 25th day of October 2025 and the 26th day of October 2025, the exact date of the offense being unknown to the grand jury, did maliciously cause Autumn Fox, a child under the age of 18 years, cruel and excessive physical and mental pain by subjecting said child to blunt force trauma by means unknown to the grand jury and exposing said child to fentanyl, methamphetamine, and xylazine, in violation of Official Code of Georgia annotated section 16-5-70, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4 reads, and the grand jurors aforesaid in the name and on behalf of the citizens of the state of Georgia charge and accuse Jessica Marie Moats with the offense of aggravated battery for that the said accused in the County of Hall in the state of Georgia between the 25th day of October 2025 and the 26th day of October 2025, the exact date of the offense being unknown to the grand jury, did maliciously cause bodily harm to the person of Autumn Fox by depriving her of a member of her body, to wit, her arm, by breaking a bone in said arm by means unknown to the grand jury in violation of Official Code of Georgia annotated section 16-5-24, contrary to the laws of said state, the good order, peace, and dignity thereof. In count 5, it reads, and the grand jurors aforesaid, in the name and on behalf of the citizens of the state of Georgia, charge and accuse Jessica Marie Moats with the offense of concealing the death of another, for that the said accused in the County of Hall in the state of Georgia on the 26th day of October 2025 did conceal the death of another, to wit, Autumn Fox, thereby hindering the discovery of whether or not such person was unlawfully killed in violation of Official Code of Georgia annotated section 16-10-31, contrary to the laws of the said state, the good order, peace, and dignity thereof. And with the indictment now read to you, Ms. Moats, are you choosing to enter a plea of guilty or not guilty?
Not guilty.
All right, I'm going to hand the indictment, thank you, Mr. Buckler, back to Ms. Moats and her counsel. Our standard language, Ms. Riles, includes the defendant herein waives formal arraignment or indictment by the grand jury. You can certainly simply cross out that information, given the fact that she's not waiving any sort of formal arraignment or indictment, and circle the plea that she'll be entering, and if you will also sign with her.
Yes, Judge.
Thank you, and I'll note for the record that Ms. Moats has entered a not guilty plea today, July 8th of 2026. All right, in regards to an amended scheduling order, defense is requesting that Friday, September 4th be the new date for the challenge for the grand jury. And then, was it August 3rd or August 7th that you were requesting to have the demurrer heard, Ms. Riles? I've set aside both of those dates. One's a Monday, one's a Friday.
August the 7th.
Okay, August 7th will be the demurrer hearing. September 4th will be the challenge to the grand jury. And you're requesting until what date to file motions?
Out of that, we had requested 90 days, so I believe that would take us to,
October 8th?
yes, ma'am.
And does anybody have leave of court the week of Thanksgiving if I wanted to use Monday and Tuesday, for instance, for non-evidentiary motions, so that you're not dealing with witness subpoenas, but we could handle, in my experience with death penalty cases, when I was a trial attorney, a lot of the motions can be addressed with simply argument back and forth with counsel. I would expect that the state would file written responses, and I think we can get through a number of motions being filed with simply argument by counsel. I'd like to set aside 2 days for that. So is everyone available November 23rd and 24th?
The state can be ready both days.
I know I can be ready, and Mr. Alexander indicates he can be ready.
All right, I'll give defense till October 8th to file any motions in addition to the motions they've already filed. And we'll set November 23rd and 24th aside for non-evidentiary motions. And in regards, I believe that for any motion that requires testimony, I'm going to look at my calendar for the month of December. I think I'm going to need the trial week that I have in December, and I have not yet set my 2027 calendar yet. I'm waiting until after the judges meet this Friday to determine caseload assignment for 2027. But I expect that it would be done by early August and would likely just go ahead and set a week aside for any sort of evidentiary motions. So if you will, if counsel will email my judicial assistant, Ms. Brookshire, with any leave that you have for the month of January and February, that would be helpful in me making my calendar around a week set aside for these motions. I appreciate Ms. Riles and Mr. Alexander filing the affidavit outlining their qualifications to serve as counsel for Ms. Moats. And I've reviewed the qualifications that have been filed both by Ms. Riles and Mr. Alexander and the Unified Appeal Procedure, and it appears that both counsel meet the requirements in regards to serving on a death penalty case. Simply for the record, Ms. Riles, the training that you have completed in 2025 and 2026, you gave me multiple days of training on death penalty cases. I think the Unified Appeal Procedure says that you have to have at least 10 hours. And just for the record, you've had in excess of 10 hours of training, correct?
Yes, ma'am, and we also have our next training scheduled for the end
July.
of this month. Yes, ma'am.
Excellent. And that's more than 10 hours, and that's the one that Mr. Alexander will be joining you at.
Yes, ma'am.
Excellent. All right, anything else that we need to address today? My office will issue a second scheduling order outlining the different dates for court, and then we'll simply add on to it once I set aside a week for evidentiary motions.
Nothing for the state, Your Honor.
Anything else from defense?
Just one moment.
And Ms. Rawls, at the first proceeding, at the last first proceeding, I gave a copy of the Unified Appeal Procedure physically to Mr. Law and Mr. Dowdy. I can certainly provide you with another, you and Mr. Alexander, with another physical copy. We have those copies with us. It's my belief that you likely already have a copy probably right in front of you in regards to the Unified Appeal Procedure. However, if you would like a physical copy or have not received that same physical copy from Mr. Dowdy or Mr. Law, I'm happy to give you another copy.
Your Honor, I do not see where either myself or Mr. Alexander need a copy of the UAP, and I believe that you've already established that you actually gave Ms. Moats a copy of it during a prior hearing.
Yes, Ms. Moats was provided a physical copy, as was the state previous defense counsel, as well as the court reporter, and that was filed. Are there any other matters that you would like addressed today, Ms. Riles?
Your Honor, I believe that covers it for today. I was just kind of glancing back through my notes.
I appreciate that, and I'm as well looking through the checklist that's been provided. I think we've covered everything, but if there's any other unique information that you want to address today, I'm happy to hear it.
Your Honor, the only thing is, I would ask this of the court, and we appreciate the court granting the motion about allowing Ms. Moats to dress in civilian clothes today. Of course, the state did not object to that. Will the court be preparing orders as we go forward, or how would that be? Because there's some of the things that I know you are ruling on, like motion number 1, to which you granted in part and, denied in part. So we just kind of, I think, need some guidance
I think
on
the
that.
best practice is to have written orders on every single motion, so that it's an easy review by the Supreme Court versus having to go back through any sort of transcripts that are done. And so we'll be issuing an order for every single motion. In regards today for, plain clothes, the court has absolutely no objection to Ms. Moats being changed into personal clothing, with the caveat that she be provided that clothing in advance of court so that it doesn't disrupt our scheduling. But the court has no objection to, and nor has the sheriff's office ever let me know that there's any sort of safety concern with having someone dressed out.
Yes, ma'am, and I appreciate that, and as does Mr. Alexander and Ms. Moats. I think my question, and I probably didn't make it plain enough to make it more specific, and maybe I didn't understand the court either, who will be preparing the orders? Because I totally agree with the court that for Supreme Court review, written orders are always the best.
I'll be preparing the orders,
Okay.
unless I specifically ask you to prepare an order.
Yes, ma'am.
This court will ensure that all orders are filed.
Yes, ma'am, it's just different judges.
Every judge
like
does it a little bit differently.
Yes, ma'am, we have it different ways in different places.
And that's where this hearing leaves us, for now. Jessica Mose has entered a not guilty plea, the judge has denied the request to delay arraignment, and the defense now has a roadmap for what comes next. A special demurrer hearing in August, a grand jury challenge in September, and a much bigger pretrial fight still ahead. What stands out here is that this wasn't about guilt or innocence yet, it was about control of the case. The defense is clearly signaling that they intend to challenge everything they can, from the indictment itself to how the grand jury was selected, and in a death penalty case, that's not unusual. Every deadline, every motion, every ruling matters because the stakes could not be higher. So now the real question becomes, is this defense strategy laying the groundwork for a serious courtroom battle, or buying time in a case that's only getting more intense?
My law clerk is very, very organized. I already have a chart, a spreadsheet, everything. She keeps me certainly on track, and we'll make sure all orders have been filed for every single motion.
Okay, thank you, ma'am.
All right, thank you. Then we'll stand in recess in regards to the Moats case.
Can we be excused, Judge?
I'm sorry?
Can we be excused?
You may, thank you.